Arkin by Jem Not Bang Waki.
Appearing for the accused person voiced by Jaintia.
Accused persons are present.
One of the accused is not present.
Who is that accused who is not present?
Jaintia. I have informed him the date, but no.
This SIE setup, he expired.
Then we will issue to another witness for Chen IO.
All right. Accused Arki Rambai, present. Accused Jemut Pang, are represented by Defense Counsel H. Pakma. Accused Boyki Rimbai,
Present.
present. Legal aid counsel Srimati E. Pasa, present. Prosecutors is also present. Prosecution shall take steps and ensure that witness is present on the next date fixed. Refix for evidence. Yes.
Jemmy Talang.
Witness present.
Okay. Who is the witness?
He's here.
Okay. Yes, next.
Chairman Lang Manare.
You know, this case we have issued someone to witness. She had received, but it seems she has to attend her daughter, youngest, for medical attention. And last date she was unwell. This time it was her daughter, she said. Malina sitting.
Last date also she did not appear.
Yes, last day she was unwell, Today it's her daughter.
Where is the accused?
He's here.
He's on bail.
Yes, sir.
Accused Kermon Lang Lamare, present along with defense counsel I Suchia. Summary issued to the witness return duly served. Prosecutor LS Yambon submits that the witness could not appear before this court today, as she has to attend her ailing daughter. This is the second time the witness has failed to appear after receiving the summons. Stop. Though, the witness has assigned reasons for an non-appearance. Prosecution shall ensure that witness is present on the next date fixed. Non-appearance of the witness on the next date fixed shall not be entertained unless it is supported with a cogent evidence. A refix for evidence. Yes.
Mr. Brown. Dinner system.
We have to witness present.
Where is the accused?
No, he's still on the way. I was informed just a few minutes back.
Arkirmai. Speaks for argument.
How many witnesses?
6. 6 minutes.
Can we hear it today? Okay, then we'll take it up after evidence.
Masukkan.
Yes. This judgment is not you.
Warrants executed.
Huh?
Warrant.
It's billable warrant.
Yes, yes.
The accused, the judgment could not be delivered due to non-appearance of the accused. The presence of the accused has been secured through non-billable warrant. Through billable warrant. Defense counsel is absent without any steps. Stop. Since, presence of the accused has been secured, matter can be posted for judgment. Fixed for judgment.
Yukilitan. Roglitan.
Your Honor, in this case, I have filed one application under section 311 Your Honor, for recalling 3 witnesses.
Yes.
They were not cross-examined by previous counsel, Your Honor, and as per their evidence, their evidence has to be cross-examined by the defense counsel for the just decision of the case.
Yes.
No, just receive it today. I'll just have to go through the case once. Can we fix on a short date?
All right. The defense counsel has filed a petition. You filed this petition today?
Yes.
The defense counsel has filed petition number 33/2026 dated 28/4/2026 under section 311, the 311 of CRPC, inter-alia, praying for recalling PW 2, PW 3 and PW 8 for cross-examination. We'll allow what's there.
Just short date.
No, but why waste time? We'll allow what is there. He did not cross-examine. Then I think why should
The accused are facing serious charge on 302.
302?
Reasons has maybe at that point of time they have declined.
They might have declined, but then of course the right to cross-examination. The lawyers these are not very. These accused persons are not from city, so they don't know. Lawyers maybe they are not aware also that what kind of a concession they're making on behalf of the accused. Once a person has, unless you can say that this is a mischievous application,
That's what
or they want to delay the matter.
check because
No, it is not a case that they are asking re-cross-examination. It is a case that the counsel did not cross-examine. So if he was not cross-examined, how can we act upon such documents? Right, file the application under section 3. What is that? What is the last sentence? First of learned defense counsel she so submits that the accused persons were defended by state defense.
Legal aid.
No, before.
Yes, legal aid.
Was defended by a legal aid counsel. The counsel during the examination of the prosecution witnesses. During the course of trial. No, after the examination of prosecution witnesses. After the examination of the prosecution witnesses, the case was taken over by legal aid defense counsel. for or on behalf of the accused. After the examination of the prosecution witnesses, the case was taken up by legal aid defense counsel. Full stop. The defense counsel submits that on perusal of the record, it has been found that the case is posted for final argument.
313.
Posted for examination of the accused under section 313. Full stop. It has come to the notice of the legal aid defense counsel that witness PW2, PW3 and PW8 who are vital prosecution witnesses were never cross-examined by the defense counsel. As such, the defense counsel praised that the three witnesses may be summoned for cross-examination. The prosecutor, learned prosecutor, prays for time to file, respond to the instant application. This court finds that this is a long pending case. The grounds on which the defense counsel is praying for recalling the witnesses is a matter of record. Full stop. Right to cross-examination is one of the vital essence of a fair trial. Full stop. In order to arrive at a just decision, parties should be given an opportunity to bring all the facts before the court. Full stop. In event of the accused being deprived of his right to cross-examination, in event of the accused being deprived of his right to cross-examine prosecution witnesses, it would not only cause prejudice to the accused, but it would also deprive the court to arrive at fair and just decision. Full stop. And this court finds that the witness PW 2, 3 and 8 were never cross-examined by the defense counsel. They are vital witnesses. They are vital prosecution witnesses. And the facts revealed by them in their evidence if acted upon without the accused being given and without an accused being given an opportunity to test the veracity of the testimony, it would cause serious prejudice to the accused. This court is not inclined to grant time to the prosecution inasmuch as the question raised by the defense is a matter of record. And deals with the question of fair trial. Therefore, the reasons discussed above, this application, no, not application, petition number 33/26 dated 28/4/2026 stands allowed. Issue summon to PW3, PW2, 3, and 8 for cross-examination by the defense. 6 for evidence.
What will the amendment?
No, this, you have taken steps, was delivered only to insurance company, okay? Okay.
Appearing on behalf of the insurance.
With regard to the driver and the owner, Your Honor, it's returned unserved. It's in Andhra Pradesh, so I'll have to take fresh steps on the owner. Your Honor.
All right, you are
And
done.
one more development, Your Honor, is just the claimant has recently expired. We'll take steps on substitution.
Okay. Another counsel for the claimant is also present. Submits that notice issued to OP owner and driver
Yes.
and return
Answer.
Unserved with the report.
The report, they've just shown that it's returned back here and one stamp is here and it's left without instruction.
Return unserved. The claimant. Another counsel for the claimant. Praise that. Praise for allowing to take fresh step.
Copies here.
Full stop. Learned counsel for the claimant has further submits that the claimant in the instant case passed away on
8/4/2026.
as such. Praise that the praise for allowing to file a substitution application. Stop. Next one. A learned counsel for the OP insurance has entered. Learned counsel see this Rimbai. AN Rimbai has entered appearance for the OP insurance. Stop. The counsel for the claimant shall first take steps to substitute the claimant. Thereafter, necessary order shall be passed. Six first steps by the claimant.
Rapor lang. This fits my share.
Honor, in this instant case, I have resigned myself as an honor advocate of the ICC Lombard. And as per the information I have received, that they yet to appoint a new panel advocate.
Who's for National Insurance Company?
I'm filing my suggested issues here.
Counsel for the OP. You filed written statement?
Yes, Your Honor, filed the statement. Suggested issue also has been filed, Your Honor.
Issues frame?
No, only my suggested issues today.
Documents? Documents you're filing?
Comments.
Yes.
Not filed too.
All right, learned counsel for the claimant P. Pide. Present. Learned counsel for the OP insurance. Learned counsel for the OP number 2. C.W. Dhar. Present. And submit that he has resigned as a panel lawyer
Yes, Your Honor.
for the insurance company. the insurance company would be engaging a fresh lawyer, would be engaging a fresh lawyer. Full stop. Learner counsel for the OP number 3, National Insurance Company, Shri A. N. Rimbai present, and has filed such issues. This court shall frame issues fixed for filing list of witnesses.
Highly appreciated. Have a good day.
Yes, please bring the witnesses.
is that there was an assault on one
Arki Rimbayan?
Monty Rumbai.
Where's Murti Rimbayan?
Monty, he expired.
Oh. Against there was an assault against one.
This Arki Rimbayan, huh?
Yes, sir. One scammed her, the victim.
The other accused name is?
Arki Rembai.
Other is Monty
Monty
Rumbai.
Rembai.
When did he die?
Victim name is Skemlang Khar.
No.
I haven't checked that detail.
I think so. It's been brought on record, if I'm not mistaken.
See the death of this Rimbai? Monty Rimbai? Yes. Yes. Give me the exhibits. Yes.
Yes, there is an assault against the accused person, victim known as Skemlang Khar. This incident took place on 6/4/2007 at about 12 midnight. If I may read the FIR, no?
Yes.
Exhibit 1. With reference to I beg to report that on 6/4/2007 at about 12 midnight, my brother Shri Skemdakhar of Pasri village was stabbed at Muthlong village by Shri
Tong village by Sri Lemon Rimbai.
and Shri Arki Rambai, both son of Roy Rambai of Pasri village. The victim was taken to KGP Synod Hospital on the same night where he succumbed to injuries. This is the FIR. And after registering of the FIR, two accused persons were arrested. One is Arki Rambai and Monty Rambai. I would like to draw this attention also on Rule Code to PW 3. PW 1 is the complainant.
Let's read the complainant first.
I received someone to appear for the court. I know the case as I am the complainant and the cousin brother of the deceased Sri so. I cannot remember the date, but the incident occurred in the month of April 2007. On the day of the incident, I was at home at Yalong village. On the next morning of the incident, the elder brother of the deceased person, Sri Bril Dakhar, came to my house and informed me that his brother, Sri Skem Dakhar, was assaulted by Arki Rambai and another person we used to call as Kheo Rambai, That Muthlong village, and died at the Mission Hospital, Joy. While learning about the incident, I, along with Bril Dakhar, Will Dakhar, and Pril Dakhar, went to the Joy police station to report the matter. On reaching Joy police station, I saw the accused person, Arki Rambai and Kheo Rambai, were already present in Thana. The accused person, Arki Rambai and Kheo Rambai, confessed at the police station that they had committed a crime and asked for forgiveness, but we did not forgive them and they were arrested by the police. The FIR was lodged by me. Exhibit 1 is the FIR and Exhibit 1 is my signature. I've also put my signature on the inquest report. Exhibit 2 is the inquest report and Exhibit 2 is my signature. I know the accused person and the accused person, Arki Rambai, is present in court today.
Yes.
PW2, you know. I know the instant case as the victim was my youngest brother. I cannot remember the date, the month, and if I am not mistaken, the incident took place in the year 2008. On the day of the incident, I was at my residence at Pasi village, but incident took place at Muthrong village. While I was sleeping during the night time, one person whom I do not remember his name came to my house and informed me about the incident. On learning about the incident, I woke up my brother who was with me at the night of the incident, and thereafter I, along with my brother, youngest auntie, went directly to the Dr. Norman Tunnel Hospital. July, on reaching hospital, the victim was directly taken for treatment as he was unconscious. After some time, the doctor came out and informed us that the victim had expired, but I could not recall the time now. After hearing the news, I was shocked and I do not remember what happened thereafter. I was informed by the doctor that the victim was stabbed by one Sri Arkirambai and he is present in the court dock today. However, I do not know the other accused person. The FIR in the case was filed by my cousin brother Emil Lekhar. I have given my statement to the police. I have no idea for what reason the victim was stabbed.
Yes.
To the briefly, the wife of the deceased.
Yes.
I know of the incident case. The incident took place on 6/4/2011 at about 11 p.m. On the day of the incident, my husband's Kamlang Khar went outside the house along with my child Krishan Lang to attend teacher's call. Suddenly, my son came to wake me up as I was sleeping, stating that his father has been kidnapped by some unknown person. Thereafter, I woke up and I heard at a distance the scream of my husband. I heard my husband shouting for help, stating that Arki Rambai and Mointi Rambai has assaulted him. I followed the path from where the scream came, and on reaching the spot, I saw my husband standing but was bleeding profusely from his chest. He was looking very weak and helpless. I immediately lay him down on the ground and shouted for help. After some time, the co-villagers came to the spot. At around 12 midnight, I, along with the other villager, took the victim to Dr. Norman Tunnel Hospital, Joy. On reaching hospital, my husband was conscious and he narrated to me that the accused person, Arki Rambai and Manti Rambai, have assaulted him. My husband succumbed to his injuries on the following day of the incident at the hospital at around 7 a.m. After the accused person came to learn that my husband has expired, they went to surrender themselves before the police. The post-mortem of my husband was also conducted at civil hospital. I can identify the accused Arki Rambai present in the court dock today, as he is staying nearby my village.
Cross.
I have given my statement to the police. The statement given before a court today that I was informed by my son that my husband was kidnapped is the correct version, and the one which I have stated before the police that one Shri Khau came and called my husband to come out for work is not correct. I stated before the police that Khau has come and called my husband the night of the incident, as this information was given to me by my husband. It is a fact I have not seen the accused person assaulted my husband on the night of the incident, but this was also informed by my husband. It's also a fact I did not see anyone at the PO when I reached. It is a fact at the time when my husband informed me that the accused person who was responsible for his assault is my relatives, my husband's relative, and other co-villagers were also present. It's a fact I found my husband injured on being informed by my son when I went looking for him, and not that I went to the PO being suspicious after my husband did not return home that night after he was called by Kev. And re-examination, Kev and Mointi Rumbai is one and the same person.
Yes.
No, this is PW4 is a Caesar witness. He's a police personnel. I joined service in the year 1994 as a constable, and in the year 2007, I was posted at Raliang Outpost. On 10/4/2007, I accompanied the IOSI LK Lengkhoi to Pasi village along with the accused person Arki Rambai. On reaching the village, the accused led us to the place where he had concealed the kukri. The kukri was concealed in a forest under the grass. The accused Arki Rambai took out the kukri concealed in the grass. I saw the accused taking out the kukri concealed in the grass. The IO made a seizure of the kukri in my presence. On being shown the seizure list dated 10/4/2007, it's exhibited as Exhibit 2. Exhibit 2 by 1 is my signature. From Malkhana, a small kukri kept under CMR, so produced for the score and being shown to witness is exhibited as Exhibit 1, Material Exhibit 1. My statement was not recorded by the IO. Cross, I do not remember exactly how many accused persons are involved in this case, but on the day of the seizure was made, it was only accused Arki Rambai who went with us.
Let's see PW5.
PW5 is the IO, one of the IO who had held the inquest. In connection with this case, I held inquest over the dead body of late Skamdakhar of Pasni village. I also prepared the inquest report of late Skamdakhar. On being shown the inquest report exhibit 2, the witness identifies his signature marked as exhibit 2 by 2. Cross. While conducting the inquest of the dead body, I found the body to be lying in his residence. It is a fact that the dead body was found in fresh condition. It is a fact the family members of the deceased victim were also present when I conducted the inquest. I was accompanied by one police constable, Els Imle. It's a fact that I have not obtained the signature of Els Imle on the body of the inquest report. There is no active bleeding from the body of the deceased victim when I conducted the inquest. It's a fact that the cut mark in the left upper lip of the deceased victim was fresh in nature. It is a fact that the cut mark on the stomach of the deceased victim was a stitch wound at the time when I conducted the inquest. PW6 is the IO. I am the investigating officer of this instant case. On 7/4/2007, the case was endorsed to me for investigation by the officer in charge of IPS. The FIR was lodged by Shri Emil Dekhar on 6/4/2007 midnight before Jawai police station that the accused persons Shri Arki Rambai and Moin Rambai went to the house of the victim, Skam Dekhar, and assaulted him with a dao, as a result of which the victim was taken to the hospital for medical treatment. But the victim succumbed to his injuries while he was in the hospital. The pre-investigation was taken up by SIBC Marak, who was on night duty at a particular night, and he has submitted requisition for post-mortem examination over the dead body of the victim. BC Marak had examined the complainant and witness. When OC of Joe IPS endorsed the case in my name, I have arrested the accused person and forwarded them to the honorable court. I have seized the weapon used in commission of the crime on being led by the accused person and prepared the seizure list. During investigation, 8 witnesses were examined and both the accused person were interrogated. After completion, the case was charged sheeted with CS number 45,007 against the 2 accused men. I could not identify the accused due to lapses of time. On being shown the exhibit 2, the witness identified signature which is marked as exhibit 2 by 2. From Malkhana, a DAO under CMR number is produced for court. On being shown, the witness identified DAO material exhibit 1, which is seized by him. Cross. The inquest on the dead body was not conducted by me since the matter was reported at Joe IPS and the officer present at Joe IPS, namely BC Marak, had conducted the inquest on the dead body, and that body was forwarded for conducting post-mortem examination by the concerned officer. It is a fact I had taken up the investigation of the investigation after the post-mortem examination was completed on the deceased victim. It's a fact there's nothing on record to prove that the deceased victim had succumbed to his injuries at Dr. Norman Tunnel Hospital. The witness, namely Shri Emil Dekhar, Shri Meril Dekhar, and Shri Bhajuk Lindor, were examined, and the statement were recorded by BC Marak, whereas Caesar witness T. Khardusao and SS Jaintia were examined by me. As per my investigation, the wife of the deceased victim is an eyewitness to the alleged incident. It's a fact that the wife of the deceased had not seen an act of assault on her husband by the accused. It's a fact the deceased person had initiated an attack on the accused when they were consuming liquor at a local liquor shop. It's a fact that there is no witnesses to substantiate the deceased victim and the accused person took up a quarrel in a liquor shop. It was the weapon used by the accused person to commit the alleged offence, which is only evidence I have collected to prove prohibition involvement of the accused person in this case. The weapon was used in commission of the offence was a kukri. It is a fact that the weapon seized as kukri was never sent for any FSL test. While the kukri was seized by me, I did not find any blood stain or any biological sample on the weapon, and the same was seized by me with my naked eyes. I have not seen the body of the deceased. I cannot say if the body of the deceased bore some injuries when he was taken to the hospital. I have not conducted inquest on the body of deceased. I filed a final report based on the statement of witnesses and the accused for alleged recovery of the weapon. Other than that, I do not find any incriminating measures against the accused. With regard to the common intention of the accused person during the investigation, I found after the quarrel of the accused Arki Rambai with deceased, he went back home and reported the matter to his brother. Thereafter, they all planned together and went to the house of deceased and executed the plan. That the accused person had not disclosed to me during the investigation with regard to the plan and have recorded them under 161 CRPC. It's a fact that the confessional statement of the accused was never recorded. PW7 is the doctor, postmortem. The postmortem examination of Skam Nakhal was conducted on 7/4/2007 by Dr. Pajbha Singkon. Dr. Pajbha Singkon died in the year 2020, but I cannot recollect the date precisely. The body of Skam Nakhal male was brought to the house of Jawais Hostel, Panalier, on 7/4/2007 at 2:05 p.m. The postmortem examination was conducted on 7/4/2007 at 2:10 p.m. The dead body was brought by SIBC Marak, UPC LLC and Shri Nil Dakhar, elder brother deceased. The body was fresh and average built man. Wounds, stitch mark on the middle part of the upper part of the abdomen. In the wall of the abdomen, there was an open incised wound with stitches on the mid upper part of the abdomen, 10 inch into 1 inch and into skin deep. Peritoneum, the injury in the peritoneum on the upper part of the abdomen, along with the open wound. Based on the finding of Dr. Pajbha Khan, the cause of death was due to shock and hemorrhage resulting from injury in the liver. The weapon is sharp, long weapon. In the liver, there was right lobe of the liver injured with bleeding.
Yes.
From all these 7 witnesses, I'm trying to prove for Honorable Court is that the victim or the wife of the victim, PW3, she has stated that when she rushed to the place where the supposedly people were, she heard the husband shouting for help and stating that Aki Rambai and Monty Rambai assaulted him. And on top of that, when she had taken him to the hospital, the deceased victim, as per the testimony of the PW3, on reaching the hospital, my husband was conscious and he narrated to me that the accused person, Arki Rambai and Monty Rambai, have assaulted him. These are the only incriminating evidence available against the accused. And along with the testimony of PW4, who is the seizure witness, it was on the leading of the accused person that the material object used for used for commission of the crime, was recovered. And also, the doctor, in the opinion of the postmortem exhibit 3, clearly shows that the offense has been carried out by using a weapon which is sharp, long edge. So this kukri is the weapon. Apart from that, the other witnesses are just accompanying the complainant who had not been part of the.
If we go by the statement of PW2, Your Honor, I read this part, Your Honor. On reaching the hospital, the victim was directly taken for treatment as he was unconscious. After some time, the doctor came out to inform us that the victim has expired, but I cannot recall the time. After hearing the news, I was shocked. I do not remember what happened after that. I was informed by the doctor that the victim was stabbed by one Arki. If we go by the evidence of PW3, Your Honor, the wife of the deceased, Your Honor, she stated, on reaching the hospital, my husband was conscious. And he narrated to me that the accused Arki and Mointy have assaulted him. So, Your Honor, there are two different statements, Your Honor. So there cannot be, Your Honor, there cannot be two versions, Your Honor. One conscious and the other unconscious, Your Honor.
What is that two different statements?
The PW2, she stated that the victim, on reaching the hospital, he was directly taken for treatment as he was unconscious. And after some time, the doctor came and informed that he expired. That means he expired during treatment. But PW3, she stated that on reaching the hospital, her husband became conscious. And it was the husband who informed her that he was assaulted by Arki and Moiti Rumbai.
What is contradictory there?
The contradiction is that the PW2, she stated that he was unconscious, which means that he cannot tell them he was unconscious. He was taken for treatment.
Does the PW2 says that when this husband was taken to the hospital, all throughout the journey, the husband was unconscious?
No, she stated on reaching the hospital with him.
On reaching the hospital, the husband became unconscious.
On reaching the hospital.
But does she say that in an unconscious state, the husband was taken to the hospital? On reaching, becoming unconscious is one thing.
Your Honor, as per the statement of the PW2, she went to the hospital not along with the victim. She went along with her brother and youngest auntie. Then on reaching the hospital, she found her victim to be unconscious, Your Honor.
So what is contradictory? She found the victim. She found that the victim was unconscious.
Was unconscious, and he was taken directly to.
So you say that what you say that this evidence is contrary, because the wife says that she took the husband to the hospital.
Yes.
He was admitted in the hospital, and then after that he was declared dead.
No, the wife, she said, on reaching the hospital, my husband became conscious, Your Honor.
Right, that is minor, conscious, unconsciousness.
It's a big difference, Your Honor, conscious and unconscious, because as per the wife, she stated that after he regained conscious, then he narrated that the accused assaulted him. But as per...
Just one second. Come to that point that where we come to the evidence of the wife, where she stated that after reaching hospital, he regained his consciousness and narrated about the incident to the wife. Come to that part. Where does the wife says that? On reaching the hospital, my husband was conscious.
Yes. He narrated to me that the accused Arki and Mointy assaulted him.
All right.
And on the following day, he succumbed to his injuries. So there's a big contradiction, Your Honor. And also...
And one second. PW says what?
On reaching the hospital, my husband was conscious. And
no, PW2.
On reaching the hospital, the victim was directly taken for treatment as he was unconscious. After some time, the doctor came to inform us that the victim has expired.
Yes.
Your Honor, my point here is that two versions
Yes,
cannot
we have taken
exist. Yes,
We have taken note.
okay. Another point stated by PW3, Your Honor, she stated, I heard my husband shouting for help, stating that Arki and Moiti has assaulted him. So, Your Honor, and on further, she stated, I saw my husband standing, but was bleeding profusely from his chest. He was looking very weak and helpless. So, Your Honor, from the evidence, it is unbelievable, Your Honor, that the victim, after suffer such a grievous injuries, Your Honor, is able to state while asking for help, he is able to state the full name of the accused, both the accused person. You know. So this statement of the PW3 is also unbelievable. You know. She's trying to exaggerate her story just to strengthen the prosecution case. You know.
What? How?
My submission is that it's impossible for the victim who has suffered grievous injuries to state the full name of the accused, Yang Arki Lambai and Monty Lambai, at the time when he's calling for help, as stated by her, but the husband shouting for help, stating that Arki Lambai and Monty Lambai has assaulted him. So her statement is unbelievable. Now, when she herself, she stated that he was bleeding profusely from his chest. He was looking weak and helpless. So my point is that it's unbelievable, Your Honor, that this is he will be able to state the full name of the accused, Your Honor, when he suffers such previous injuries, Your Honor. And that too, she could heard from a distance, Your Honor.
Yes.
And in the cross-examination of PW3, Your Honor, she stated the statement given before the court today. I was informed by my son that my husband was kidnapped is the correct version, and the one which I have stated before the police that Kev came and called my husband to come out from some work is not correct. I stated before the police that Kev has come and called my husband on the night of the incident, as this information was given by my husband, Your Honor. So, Your Honor, my point here is that the PW3 is changing her own statement. She denied the statement which she has given before the police, Your Honor. And even the information she received from her husband, which she has stated before the police, she denied it before the court. She stated that I stated before the police that Hale has come to call my husband the night of the incident, as this information was given by my husband, where she denied it before the court that it was not a correct statement, Your Honor. But that information was received by her through her husband, Your Honor. So now, PW3 contradict herself, Your Honor. The IO, Your Honor, PW6. He admitted his evidence that there are no incriminating evidence against the accused except the recovery of the weapon. It was a weapon used by the accused person to commit the alleged offense, which is the only evidence I had collected to prove prima facie involvement against the accused person in the instant case.
Which
so,
paragraph?
Paragraph 10 on IO.
In cross-examination?
Cross-examination.
Yes.
Your Honor, in his chief, Your Honor, in paragraph 5, the IO have stated that I have seized the weapon. I have arrested the accused person and forwarded them to the Honorable Court. I have seized the weapon used in commission of the crime on being led by the accused person and prepared the case list. Your Honor, from the evidence of this PW, this IO, Your Honor.
Which paragraph?
Paragraph 5, Your Honor.
Of chief?
Last line, in chief. He stated, I have seized the weapon used in commission of the crime on being led by the accused person and prepared by the case list. Your Honor, from the evidence of the IO, nothing transpired that the accused stated before the IO that he hit the weapon, and this was a weapon used in commission of the crime. Nothing transpired from the evidence of the IO, Your Honor. And Your Honor, I would like to rely in the case of Supramaya versus State of Karnataka, Your Honor, for recovery of the weapon, Your Honor. It was stated that if it is say of the investigation officer that the appellant accused, while in custody on his own free will and volition, made a statement that he would lead to the place where he had hidden the weapon of offense, the site of burial of the dead body, close extract. And the first thing that the investigation officer should have done was to call for 2 independent witnesses at the police station itself. Once 2 independent witnesses would arrive at the police station, thereafter,
This case, which year?
Supramanya State of Karnataka.
Which year?
2022 Your Honor.
2000?
2022. 2022 Your Honor. I'll go through it.
No, we are aware. We are aware.
Okay. So as per this ruling, Your Honor, there's no independent witness in recovery of the weapon, and that, as stated by the Caesar witness, it is fact that it was only me and the IO of the instant case who had accompanied the accused on the day of the seizure was made. So from this evidence of the Caesar witness, it was only the he who is a police Your Honor, and IO who went to recover the weapon, Your Honor. So it is doubtful, Your Honor, whether the weapon was recovered at the instant of the accused. So it is doubtful, Your Honor. And also another point is that, Your Honor, the IO had admitted in his evidence, it is a fact that the weapon seized at Kukri was never sent for FSL, for forensic test examination. The said Kukri was seized by me. I did not find any blood stain or any biological sample of the weapon, and the same was seen by me with naked eyes. So, Your Honor, even the Kukri was not provided. It's used for commission of the offense, Your Honor. So, Your Honor, I pray that the prosecution has failed to prove, since there are no incriminating evidence against the accused, and the seizure was not made in accordance with law, Your Honor. This under ruling is citation, Your Honor, I'd like to rely. It is Kaligram versus State of Himachal Pradesh, Your Honor, regarding the statement of PW2 and PW3. There are 2 points here, two views, one conscious and the other unconscious, Your Honor. So I would like to rely on this, Your Honor, when there are 2 views possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence. The view which is favorable to the accused should be adopted. So I would like to rely on this decision. Your Honor.
What is that 2 view?
2 views, one is conscious and the other is unconscious. And
How does it affect the merit of the case?
pardon, sir?
How does it affect the merit of the case?
Your Honor, one witness stated that the accused was conscious, and he narrated that the so-and-so accused of assaulted him. And the others, he stated that he was unconscious. That means he cannot narrate it, that the accused assaulted him.
Who says that the accused was brought unconscious?
The victim, I mean, sir. The victim.
Who says that the accused was brought unconscious to the hospital?
The victim was brought unconscious.
Who says so?
PW3, sorry, sir, PW2. He was brought unconscious. And PW3 stated that on reaching hospital, he gained consciousness.
Now, PW2 was the person who brought the victim to the hospital.
She stated on reaching the hospital, Your Honor.
PW2 was the person who brought the victim to the hospital.
It was PW3 who brought the victim to the hospital, Your Honor.
My query to you is that was it PW2
No.
was the person who brought the
As
victim
per
to the
her
hospital?
evidence, she did not state that she went along with them, but from her evidence,
My question is your argument is that when there are 2 witnesses, they brought the victim to the hospital. One of the witnesses says that he was conscious, another witness says that he is not conscious. Then your argument gains force.
it was PW3.
If somebody was standing in the hospital, all right, somebody was waiting there in the hospital when the deceased or the victim was brought to the hospital. That person says that when the victim was brought in the hospital, he was unconscious. But the person who brought the victim to the hospital all throughout found that the victim was conscious, not only conscious. When he was conscious, he revealed the name of 2 accused persons involved in causing the stab injury. Is that not a dying declaration?
One more point, Your Honor, I would like to bring from the evidence of PW3.
Yes.
In her cross-examination, she stated, it is a fact at the time when my husband informed me that the accused was responsible for his assault. My relative, my husband's relative, and other co-villagers were also present.
So,
But as per the statement of this PW2, who is a sister of the deceased, she never stated that, Your Honor.
PW2, when did the accused, the deceased inform that the involvement of the accused? When?
At the hospital, Your Honor. after he regained consciousness, as per the statement of PW3. And in her cross also she stated that the relative of the deceased and her relative was also present.
Of course, this may not have been recorded properly on reaching the hospital, because you see, PW3 was with the deceased. She took her to the hospital from the place of occurrence.
Yes, and also her statement, if you go by her statement.
I, along with the other villagers, took the victim to Normal Tunnel Hospital, Joy. On reaching the hospital, my husband was conscious and he narrated to me that the accused Arki Rimbai and Moti Rimbai have assaulted him. All right.
Yes.
So, my husband succumbed to his injuries on the following day of the incident at the said hospital at 7 a.m. Okay. Now, you have PW2. Who is PW2? Is the sister. So they don't know. They say that on reaching the hospital, the victim was taken for treatment as he was unconscious. So she's just making a statement. Did she see the victim? How did she know that she was unconscious? She never accompanied. This PW2 never accompanied the deceased. On reaching the hospital, the victim was directly taken for treatment as he was unconscious. She was there. On learning about the
As per
incident.
her statement, she knows that he was unconscious, as per her statement.
See, on learning about the incident, I woke up my brother who was with me at night of the incident, and thereafter I, along with my brother and youngest auntie, went directly to Norman Tunnel Hospital, Joy. That means on learning about the incident and learning that the brother has been taken to Norman Tunnel Hospital, they went to the hospital. On reaching the hospital, the was taken for treatment as he was unconscious. Now he was taken for treatment. They didn't see him. He was already taken for treatment. After some time, the doctor came out to inform us that the victim has expired, but I could not recall the time. When was the victim taken to the hospital?
On the same day.
Did he die on the same day?
As per statement of PW2, he died on the same day.
When did he die? As per the evidence of the doctor.
As
The incident took place on 6.
yes.
He was taken to the hospital on 6. When did he die?
As per the postmortem, he died. The postmortem was conducted on 7/4.
Oh, it doesn't matter when was the postmortem conducted, but when he died.
As per the statement of the PW3, she said on the following day, 7 a.m.
7 a.m. So,
It should be 7.
Because the incident happened at midnight,
yes.
as stated by the complainant. So it will be on the 7th of the year. From her statement of PW2, she knows that he was unconscious.
Huh?
From her statement, she knows that he was unconscious.
How?
She stated herself he was unconscious.
Did she see? She went to the hospital only after learning about the incident that her brother has been taken to the hospital. She followed her brother. When she reached the hospital, she was told that the brother was taken for treatment. She did not see. How did she come to know that the brother was unconscious? You need to cross-examine on that matter.
No, Your Honor, that was not processed.
Then, any cross-examination on that matter?
No, Your Honor.
Who told the doctor that the person was? Hmm. Yes, yes. Okay, we got your point.
Okay.
Hmm. Yes.
have mentioned that, Your Honor, as stated by PW3, that at the time when my husband informed me that the accused person responsible for assault, his relative, my husband relative, and other co-villagers were also present. But
Yes,
none
we'll
of them.
Taken.
Okay,
Taken.
that's my point, Your Honor.
All right.
I would like to submit this citation also.
On what point?
This Kaliram on that point, Your Honor, that consciousness and unconsciousness, Your Honor, and this recovery of weapon, Your Honor, in case of Subramania, as a state of Meghalaya.
Yes.
I'll get it.
Yes. Anything in the prosecution wants to rebut?
Yes, yes. You know, on the point of dying declaration, I have one citation, but now it's not with me. I'll just hand it over to the court. Which says that the previous statement of the deceased, as the deceased has stated to the wife, it has to be taken on record, because she was present right from the time when he was taken from the PO till the hospital, and she clearly stated he was conscious at that point of time till he was taken for treatment. Post that, he became unconscious.
Yes.
I will supply the citation to the Supreme Court.
Then we take it tomorrow. We'll come with the judgment tomorrow.
Yes, sir.
All the double counsels, this matter will come up tomorrow. You can place me the decision. See, those decisions will not be relied. So far as the prosecutions, nobody's argument is that statement made by the accused, which led to the recovery. We are not saying that the prosecution is not arguing that the recovery being led by the accused is admissible under section 27 and it is a substantive piece of evidence. That's not their argument. They are solely relying, because we know the cookery was seized, whether it was the cookery used, nobody has seen. Nobody has seen.
But it was seized.
It was seized. Yeah, we agree that the seizure in accordance with law and seizure being made on being led by the accused is two different things. Because accused first has to be in police custody, two independent witnesses has to be there, recovery statement has to be recorded before proceeding for recovery, and thereafter when the recovery is made, seizure has to be made in presence of those two independent witnesses before whom the recovery statement was made. And with regard to the commission of the crime, if the accused says that I have committed the crime, that admission will not be admissible under law. Only the statement with regard to the accused leading to the recovery made under section 27 will be admissible on law. Only that part, not confession. If the accused says that I have stabbed somebody using the knife and I have concealed the knife, then the accused leading to the recovery to the police is admissible under law. But confessing before the police that I have committed the crime, that is not admissible under section 27. That is not admissible. Again, it will be hit by section 24, 25, 26. Only limited, only to the extent of the accused leading to the recovery. Because that is against the accused. So statement before the police will be admissible only to that extent, that he has led to the recovery and those incriminating materials or the weapon of crime was seized on being led by the accused. So that is not their case. Prosecution is not heavily relying on the recovery of the weapon. They are aware that even if the weapon is recovered, nobody saw. If if it's a case that there is an eyewitness, and then the question of connecting the weapon with the crime does not arise. Because somebody saw, why should we look for forensic evidence and everything? Now, even if the weapon was recovered, how do they connect the weapon with the injury? There has to be an FSL report. Or the nature of injury is such that it matches with the weapon used, sharp cut. But just because a weapon has been seized and the injury also is with a sharp weapon, automatically we just cannot connect. These are circumstantial evidence. A circumstantial evidence has to be, they say that no, before the incident also somebody saw him with the kukri. And this kukri belongs to him. Fingerprints are there. So that they are not. But we are on a very larger question, is that you were there in the house. The deceased was there in the house. We are aware that the child who informed about the incident was also not examined. We are aware of that. Who informed about the incident to the wife? It is indifferent, insignificant now. Whoever it informed, it does not carry any meaning because the wife saw the husband outside, and that too it was late night. And then she saw the husband with an injury, profusely bleeding, and she took the husband to the hospital, and he died. On the way, the husband said to the wife that these two persons had caused injury to me, the stab injury. That's all. That's the case. And why should we not believe the wife? And why will a person take somebody's name? Why will somebody take, then they come back to section 32. There is no hard and fast rule. If your argument is this, that look, the person was very seriously injured. The injury was such that he was not in a position to make any statement. Then it becomes doubtful. And why on this earth he will take a name of two, your name? Why? And usually 32 stands on that principle that a man before dying will not implicate a wrong person. And he's an eyewitness of who stabbed him. So that's the only question, is that why should we not believe the wife? Simple as that. If your argument is that the person was not conscious, not conscious, that is not. PW2 was never traveled with the deceased. PW2 did not travel. Look, from the evidence of PW2, it emerges that after learning about the incident, why did she go to Norman Tunnel Hospital? PW2?
She went directly.
Why? Because she was informed about the incident, not about the brother being stabbed. After being stabbed, he has been taken to Norman Tunnel Hospital for treatment. So she's not a party to the thing. The only thing, limited argument you can argue, is that the PW2 could not, the deceased was so badly injured that he was either not in a fit state of mind to make a dying declaration to his wife. Only this much. And you place that decision we'll take it up tomorrow and be disposed of.
Okay, sir.
Convince only on that part to us that it was not possible for the wife, for the deceased to make a dying declaration, because dying declaration, a person first has to be mentally fit to make a dying declaration. Being weak, you don't lose your mental capacity to make a dying declaration. From the postmortem report, we say that the injury was of such nature that it was practically impossible for a person to have any kind of a conversation with anybody. And if at all, if any conversation was there, it cannot be taken into consideration because of the nature of injury. Person was not mentally balanced. Take tomorrow.
Yes.
Give those two judgments also. We will read. So tomorrow we'll not keep any more judgments pending. Yes, that's all. Yes. Anything? What we have?
No, but that judgment almost
Almost very easy. He's come. No, but we have come on the bailable one. We'll do
Next
deal with somebody. Today he's come on the bailable warrant. Record later at Defense Counsel appeal. Yes.
I would like to make a simple request, Your Honor, to this honorable court. In this Ilam case, Your Honor, it has been pending for 1 year for the judgment.
You finished.
almost.
No to even updated.
100
So, it was fixed for judgment from the 8/5/2025.
Actually, judgment Monday only.
Yes, Your Honor.
No, Tuesday.
Tuesday. Like,
Yes, I have one bail applications. Yes.
What is that? What is that bail?
Pardon, sir.
What is this case?
This case is charged under section of 64(1) BNS.
Rape case.
Yes.